Good morning. Welcome to the Oldham County Board of Adjustments here an appeals meeting. It's Thursday, December 18th, 2025. We have three items on the docket for this morning. I'm going to go over the order of how the meeting will progress, and then we'll swear in staff. So first, we're calling the meeting to order. We're going to swear in staff, and then the secretary will help us with introducing the applications along the way. We'll have staff reports from each of the staff members about the applications, and then we'll have a presentation by the applicant or their legal representative that will take 20 minutes, no more than 20 minutes. We'll have the applicant come forward. They'll need to state their name and address and get sworn in. Then we'll have questioning by the applicant by the board. Then we'll have testimony from anyone speaking in favor of the applicant, and that will be limited to 10 minutes. And they'll be sworn in as well. Then we'll have questions of the board of that person. And then we'll have testimony from anybody opposing the applicant, limited to 10 minutes, and then questioning by the board. Then we'll have rebuttal by the applicant, a rebuttal by the opposition, final statement of the opposition, final statement of the applicant. Each of those, all of those are limited to 5 minutes with no new testimony. And then final questioning by the board of any party. Then we'll close the floor and we'll have discussion among the board, and then the board will make a motion and second, and will approve or disapprove the application. So with that, we will swear in staff first.
Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth? Thank you.
Okay, so the first item on the agenda is OC 25-49, and we'll have an introduction by the secretary.
So you want to read the item, and then we need a motion to remove it from the table so it can be considered.
Okay. OC 25-049, an application has been filed requesting a conditional use permit for a short-term rental property located at 6000 South Highway 53 in Smithfield. This issue was tabled at the November 20th meeting. Can I get a motion?
So we'll need a motion to remove it from the table.
Motion to remove it from the table.
Is there a second?
I'll second.
All in favor?
Aye.
Opposed? It's unanimous. Okay.
Good morning, Mr. Chairman,
Morning.
Mr. Baxter, Ms. Edgar, members of the board, John Hine, Planner 1, Oldham County Planning and Development Services. This case was fairly well explained to you guys at the last hearing, but I'll just do a quick recap. If you have more questions, we can delve into it deeper. This case is involving a conditional use permit for a owner-occupied short-term rental at 6000 South Highway 53 in Smithfield. This is the property in discussion, and all relevant documents for the short-term rental were turned in. They were adequate for the short-term rental permit to be issued. The snag came towards the end of the meeting when we discovered that Mr. Bowman was in the process of transferring the property from the LLC that he was the sole proprietor of to his own personal ownership. That has been completed. He's submitted the deeds for that. We have them here. And then there was the one issue that occurred that will be included in the binding elements, in which this second home on the property will need to be parceled off as it is not in conformance with our current regulations. Excuse me. So yeah, these are the binding elements. We have our three regular ones. Conditional use permit shall only apply to the application considered at today's Oldham County Board of Adjustment public hearing. Application shall comply with all regulations concerning short-term rental properties outlined in Oldham County Zoning Regulations Section 250-050. Conditional use permit shall be automatically revoked upon transfer sale of the property, which again is why this was tabled and is coming back before you now, is that transfer has been complete and avoids him having to come back before you. The applicant shall apply for and be issued a short-term rental property permit and license before renting the property, and the owner shall submit a minor plat application separating the second structure to an independent parcel prior to the issuance of the STRP permit. If you guys have any questions for me, I'm happy to answer.
Thank you. Would the applicant like to come forward?
Mr. Chairman, members of the board, Mr. Baxter, Ms. Edgar, good morning. Mike Swansburg, 117 West Main Street here in LaGrange. I also have with me Mr. Timothy Bowman, who is here, who testified in front of you all last month about this particular project. I just want to, I'm not going to go back into the full presentation again.
Just, if I might just stop you for, the reason that he's not being sworn in is he's an attorney, so he does not need to be sworn in, right?
That, he is not an attorney. I am an attorney, but.
Right,
Oh,
you're
for
not-
me? Oh,
yeah,
yes,
you're
sir.
not
I'm
being
sorry.
sworn in now because you're an attorney.
Yes, yes, sir. Thank you. I'd be happy to get sworn in, though, if you need me
That's
to
all right.
officially. But just for everyone's benefit, again, I'm not going to go through the entire thing. This was the presentation we gave last month. Again, we've already seen the image of the property and the current zoning and what the standards are. That's the information showing, again, this is an owner-occupied property. That's Mr. Bowman. You can see his face on that driver's license there on your screen. It is the same individual. At least I believe it to be the same individual based on my observation. And then showing, again, some additional proof of residency. And we talked a little bit about the layout of the home, the justification, how it's consistent with the comprehensive plan. And then this is the summary. This is really the part where we kind of left off, and the part, quite frankly, that I would like to just reiterate. We are, again, asking for the approval of a conditional use permit so that the home that we talked about, again, in length last month can be used for a short-term rental purpose. And it does qualify for the permit because it is an owner-occupied host property. As we talked about, again, Mr. and Mrs. Bowman own that property. They live there. That is their residence. So that is it qualifies as owner-occupied host property. We talked about security. We talked about cameras. We talked about the necessity to ensure that the neighbors are not bothered to the extent absolutely possible, and how at the end of the day, Mr. Bowman and his wife would ultimately want to work with the neighbors to ensure that any of those issues are addressed either before they become an issue or as they arise, to the extent that is an issue as well. It also qualifies because it's essential and desirable to the applicant, his family, and the community at large. We talked a little bit last month, if you recall, about the fact that this property is just down the road from an event venue that we talked about. And just to ensure here, we'll show it. Again, we're talking about it being just down the road and how there's some synergy between that and local event venues for the purpose of having a place for individuals who might be participating in those venues in some form or fashion, whether it's a wedding, whether it's another event where they may be able to stay as part of that particular event. And so that is, again, consistent with and desirable to the community at large. The barn at Twin Lakes is specifically that venue we talked about last month. And then, of course, we also talked about at the last part here how it qualifies because it does comport with the objectives of the Oldham County Comprehensive Plan. And just again, talk about how, again, it is justification is desirable because it provides a country getaway. Its usage is desirable because it provides supporting accommodations. It's essential to the applicant because it provides a supplemental means of income for them on that property. How is it consistent? Again, we talked about LU-3-1, land use objective, which is one of the reasons, or how it comports with the comprehensive plan. We also talked about business and industry goal BI-1-2, supporting those existing businesses to thrive and grow in Oldham County. So again, it's that synergy between this property and other properties in the county and how they can ultimately support each other to essentially lift everybody in that particular area of the county. The only other issue that we had that came up toward the end, as Mr. Hine already indicated, is the fact that there was a discrepancy in the transfer and who owned the property. It was an LLC at the time. There was discussion because the application was actually filed by Mr. Bowman individually. We wanted to make sure that it was clean. I just went ahead and put on here for everyone's benefit. This is the deed that actually transfers ownership from that LLC 3105 Hunzinger to Mr. and Mrs. Bowman in their individual capacities. So it does now at least from my perspective, clean up that issue that we had before. This particular one, for your benefit, is not stamped. However, the one I got was not stamped because it hadn't been stamped at that time. It has since been recorded with the clerk's office and is now officially a matter of public record. So this is the deed that transfers ownership over to them individually, and again, has been recorded with the Secretary of State's office. So just in sum, again, talking about those particular qualifications and why it might otherwise meet the standards for a conditional use permit for short-term rental property, we do believe that it meets all of those criteria. And now that the matter of the ownership has been rectified, we believe that this matter is perfectly ripe to move forward for and hopefully receive your approval. And I'll be more than happy to answer any questions that you all might have about this particular project. Thank you, Mr. Chairman.
So I have just a question for staff. Does staff need a stamped copy of that deed, the quick claim deed, or do you already have it?
Mr. Bowman provided it to me this morning. I just didn't have time to print it off and bring it to you guys.
All right, thank you. Okay, does Mr. Bowman want to testify? That's fine, you don't have to. Yeah, okay, good. All right. Questions by the board?
I just wondered if you had made any additional attempts to make your neighbors more comfortable with this scenario?
And you have to state your name and address.
Well, so now we need name and address and swear you in, so.
Tim Bowman, 6000 South Highway 53, Smithfield, Kentucky, 40068.
Do you solemnly, raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you.
I'm sorry, what was the question?
I just wanted to know, the last time we were here, a couple of neighbors came up and testified that they were concerned about this, and I wondered if you had had any additional conversations or made any progress getting them on board with us.
No, we haven't spoken since the last meeting, but I'm very open to have a conversation with him and communicate with him.
Okay. Anybody else? No? Okay, thank you.
Thanks.
So now we have testimony from anyone speaking in favor of the applicant? Nobody? Testimony from anyone speaking opposing the applicant?
Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
Thank you.
My name is Jeremiah Morgan. I had spoken last time. Still have the same concerns.
Do you have the information?
You know, I have a 13-year-old daughter that's home by herself a lot. This is a farm. I mean, this is not a residential neighborhood. This is a farm. And we're bringing people out to, you know, basically use this as something to which I don't believe it's even intended for. It's, you know, this is a house on a farm. Now I've got people coming in and out of the driveway. I don't know who they are. It's a private drive. I still have the same concerns of liability of, you know, if someone gets hurt on the property, on the driveway, who is responsible? If I own half the road, I'm going to be sued just as soon as he will if somebody files a lawsuit. Those are my concerns. I haven't changed my position since last time. Mr. Bowman has not reached out, spoken to me since. He and I actually haven't spoken since last summer, and other than when we were here, we haven't spoken. I'm not sure if he wants to have a conversation, but I'm open to a conversation, but my position is still the same on this and will still be the same, whether it's Mr. Bowman that owns the property or not. I'm not comfortable with it next to me. I just really don't want it. I feel like, you know, I've got a stake in this. This was my forever home. I moved out here to get away from those type of things, and I'm just not on board with it.
Okay. Questions, board members? No? Okay, thank you. Okay, is there any rebuttal by the applicant?
Hold on just a second. Yes, hold on. Are you sure there was no one else that wanted to speak in opposition?
Oh, I'm sorry. Is there anybody else speaking in opposition? I'm sorry, yeah.
Hi, I'm Joe Farmer. I'm a neighbor.
with this resident here. Do you need to get sworn in?
What was your last name again?
Joe Farmer.
Farmer. And what is your address?
It's 6606 Timothy Circle.
Okay, raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Okay, I came here last time just out of curiosity, just to find out what was going on with the neighborhood, and I did not like what I was hearing. It was, matter of fact, it's the whole meeting was a falsehood on why we were meeting, because it was a corporation. I'm glad Barry brought that to the forefront, because now they're changing it over to an individual. But some of the things that I learned from the last meeting is this: that they're looking at a 6-month short-term rental. Well, to me, that's not short-term. If it were truly to support the neighboring business, Twin Lakes, it would just be for the weekend. And they have access to other venues, hotels and so forth, to where the people can stay out of town. So that would be, and honeymooners are just getting married and they're getting out of town. They're not looking to stay any length. They certainly aren't looking to stay 6 months. The shared driveway thing, I don't see how you can overcome that, because when you're running a business, each time somebody uses that driveway, it's a shared driveway. So somebody's trespassing if they don't have approvals. There is no agreement between Mr. Bowman and Twin Lakes whatsoever. It's not going to support that existing business. It's been in business for a while. They support themselves. So it's totally separate issue, situation, and everything. We found out there's 2 homes on the property. It's 2 structures now. Maybe this needs to be rezoned to R2, because we're talking about 30 plus people. It uses our infrastructure. They're not paying any taxes. They're using our schools if there's children involved. So that's something that needs to be considered as well. I know if I look to split my property, it would have to fit those needs as far as being able to support the infrastructure. Also, we found out that Tim doesn't live there either, so I don't know how you can manage it from afar. I live 1 mile from the property. It would be hard for me to manage it and see what's going on there. So I just don't know how you can do it from afar. His counsel said it's not in Florida. No, but it's not at the property, and it's a good drive from anywhere in Louisville to that facility. So I would just like to be considered those aspects before approving this. Thank you.
Okay, thank you. Anyone else opposing? Okay, then rebuttal by the applicant.
Well, I was going to keep this short, and I'm going to try to still keep this short, Mr. Chairman, but as a practical matter, we heard a lot of statements made a few minutes ago, all of which I believe were actually addressed and quite frankly refuted last month. Talking about a 6-month rental, for example. Yes, the regulation provides that you can have a short term up to a certain point, but the testimony last month, if we all remember, was in fact that Mr. Bowman was talking about he and his family doing it on an occasional basis. Why? Because it's still a residence for them. That's still their home. So you're not going to rent it out for 6 months and then have someone stay there the entire time. This was supposed to be and continues to be a short-term rental opportunity for them to fill in certain gaps and make some money off of this. I'm not entirely sure how it won't actually support the Twin at Barn Lakes just across the street, simply because it's a venue that's across the street from them that provides an opportunity for people to stay there. So I'm not sure how it won't support them at the end of the day. I suspect they probably would think, although I won't speak for them, they suspect they would think it would be helpful for them to be able to cross-market an opportunity potentially to stay across the street from them. We talk about, for example, the ownership of the property. We've already gone through this. We've gone through this ad nauseum, I would argue. We've put up all the proof in there about residency at the end of the day, and I don't know what else I can do other than physically have people show up and look at his home every single night to find out, which is completely inappropriate and wouldn't be a measure of, it wouldn't be something we would want to do anyway. I don't know that anybody would want to be able to be under that particular standard. So the proof in the record demonstrates that Mr. Bowman and his wife live at the property. He's got all the documentation to prove it. It's all been in the record at this point. Again, I'm not sure whether folks are staring in windows every night to try to get you in some way. Oh, you're not here tonight. That means you don't live here. Oh, you're not there last night. That means you don't live there. I'm not entirely sure what is going on that front, but I do know at the end of the day that the proof in the record and the testimony that was made is that he lives there. It's his residence. So again, I'm not sure what the issue is on that front. I don't know how many more times we can actually try to rectify or disprove that issue. We talked about the fact that there are two residences on the property, and one of the binding elements is going to be that one of those is going to get parceled off. And we've agreed to that. That's not a problem for this applicant. That's going to be something that addresses that issue. It's not going to be part of the property that's actually approved for purposes of short-term rental. It's going to be a separate property. So that is not an issue anymore either. So again, the standards that we talked about, the standards that this body needs to look for were the ones that we talked about last month. And we go through, is it consistent with the plan, for example? Is it owner occupied? Are they going to have to do all the other hurdles of a short-term rental with planning and zoning to get the permit for short-term rental? Yes. So there's still additional barriers for them to do this that they will still have to work through and work with planning and zoning to make sure that that happens as well. And they plan to do that, assuming you all approve this. So again, this is not just kind of a fly by the seat of the pants project. This isn't just a, we're going to get you all to prove it, and then all of a sudden, gotcha. We've got this, a complete farce that's going on at the end of the day. There is going to continue to be a process whereby they have to continue to meet certain standards in this county to be able to use this property in this manner, and they plan to do it. Yes, ma'am.
Can I ask a question? I think the residence issue, is this his primary residence, meaning this is where he lives full-time? He doesn't have other properties somewhere else where he also divides his time?
So by law, as long as you are there 6 months and 1 day in a year, that is your primary residence. So you can actually technically have more than one, and you can actually split your time between them.
Okay.
And that's perfectly fine. But as a practical matter, the answer is yes, it's his residence.
I can just understand from his neighbor's perspective, the way you feel comfortable with this happening is this is their primary residence, so they are supremely invested in making sure that the people coming in and out are on the up and up, that nothing's getting damaged. And so the neighbors consistently saying there's something else going on, that there's another property, or I can understand how that makes them feel concerned that.
Sure. And I do appreciate that at the end. And I don't want to discount that there are concerns about it. There's always concerns when as a practical matter, anytime you have a short-term rental request, there's always some concern of some kind. There's never been, to my experience, there's never been a short-term rental request where somebody didn't have a concern in some way. I totally understand all of that. The concerns and the reason why, if I appear to be animated on this, the reason why in some ways is because there are issues that were fully discussed last month, and I'm not convinced at the end of the day that what was discussed was relayed in some way or understood at the end. So Mr. Bowman and his wife have every intention, as we talked about last month, of ensuring that this property is maintained and that at the end of the day that it is being watched, that there are cameras. He indicated there are cameras. And he's also discussed that he is more than happy to talk to the neighbors about ways to potentially remedy that shared driveway situation. And that has been my advice as well, is to ensure that that is a conversation that they have, and to make sure that that is an issue that is addressed. Because again, you don't want nobody wants a situation where something happens on that shared property and then it's who's liable at the end of the day. So that will continue to be a goal for them. It will continue to be one of their efforts to reach out to neighbors and make sure that any issues that are coming up are going to be addressed. Yes, ma'am.
So the documents you presented to verify residency, the driver's license and some utility bills, was that the same address that's on the application? I didn't cross-check those to make sure that they're all the same.
It is. It should be, yes.
Okay. And does planning have copies of all that you presented?
Actually, I think I got it from their report. So
okay, because it's not.
Mr. Bowman, I think, sent it to me,
it's
but
not
also
in the staff packet. I just want to make sure that we have evidence that. Yeah.
Normally, those are included in the STRP package. I've started including them more recently in the staff packet because it's such a point of contention. If it's not in this one, I do apologize. But
okay, but we verified that the
yes.
address is the same.
Yes, Mr. Chairman.
Okay, good. Ryan?
Ryan Fisher, Director, Oldham County Planning. I just want to give two little side notes on the short-term rental ordinance. I just want to make sure that the board is clear on. One is the short-term rental ordinance only pertains to any rental that's less than 30 days. So right now, the owner could rent his house out for a year. He could rent his house out for 6 months. He could rent his house out for 31 days with no appearance before you all, with no application within our office. He has got the right to do that as the owner of his home. So the short-term rental ordinance and this application for a conditional use permit for a short-term rental only pertains to any time he would rent his property for less than 30 days in length. The other thing about the short-term rental ordinance is originally when we were making changes to that about 2.5 years ago, once the short-term rental industry really started evolving, was we had originally put in the ordinance that it had to be your primary residence, period, end of day. 365 days a year you resided there to be considered an owner occupied. Based on a lot of feedback from people in this community, when we went through our short-term or our study review committee process, when we went through all of our hearings, there was a lot of people that live in this county that in the winter, guess where they go? They go to much warmer places. Last week, I wanted to join them. But at the end of the day, there was a lot of feedback from people that said, if you do that, then you take away our ability to rent our property in those months when we go to Florida. And so that's why it got changed to the 6 months and 1 day, was for a lot of people in the community that complained about the original proposal, which was it had to be your primary residence 365 days a year. So I just want to give you all a little backstory on how that 6-month thing came about, based on, once again, feedback from people in the community. So it wasn't just something we went at planning and went, you know what, let's make it 6 months to. So I just want to give a little side story on that. So,
Thank you, Ryan.
One more technical question. Is it correct that the second parcel that's split off will not receive this conditional use permit?
So correct. So one of the conditions of approval is that has to be split off. Actually, looking back, I was doing something else, and I happened to, when we were doing your all's training for the Board of Adjustments training, when we did the minor plats, one of those examples was the property where it had been consolidated from 2 parcels into 1. That was actually one of the examples we looked at. So that just needs to be redone. Go back to 2 parcels, and you're right, that parcel would not be included on this particular thing. And that has to be done prior to them getting that short-term rental.
Okay, thank you, Ryan. Okay, so that was rebuttal by applicant. I guess, did we do everything? Let's see. Rebuttal by opposition, yes.
Yeah, Joe Farmer again. This isn't personal. I liked him, but we had a totally different conversation when I was putting some water on my property, and he was concerned about me parceling off my property. So this whole thing has changed its situation. But anyway, as far as I think Tim has owned the property less than a year. When I purchased my property over 2 years ago, I was told I couldn't split it off within 5 years. So it sounds like they're trying to split off a parcel here before that 5 years is elapsed. And I don't think that's part of the rules, or at least that's what I was told. Also, there needs to be an address for each property on the driveway. And I was told that you could have 5 maximum per driveway, and I think they're at that limit. So if you start adding parcels, it's going to exceed that limit. As far as snowbirds going down to Florida, I know a lot of people that do have vacation homes down in Florida, but they don't lease out their homes. They don't want strangers in their homes when they go down there. They have enough money that they can withstand the rent and so forth, and they want to come back home to their home without someone else being in it. That's all I have. Thanks.
Okay. So the next thing is final statement by opposition.
Mr. Chairman, sorry, before you get to that, I think Mr. Fisher needs to come up and explain what the ordinance actually calls for relative to the things that Mr. Farmer said, just so that we are clear about that.
So as far as the splitting of parcels, so you can create 2 new parcels off of a tract every 5 years. This was essentially 2 tracts that were consolidated into one previously. In the plat that I was just referring to that was in your all's training class, that was a consolidation. That does not count in the number of splits. That is, you've got a parent tract, you can have 2 children off of that parent tract every 5 years. If you want to create more, you either have to do a preliminary subdivision plan and go before the Planning Commission to create a subdivision, or you go before the Planning Commission and ask for a waiver of the minor plat rule, which we've also heard cases for. But this isn't creating a new parcel. This is, he's correct in his wording of what the rule is, but this is not that. He's not creating a parcel. We're essentially taking it back to the way it was before so that you can't have 2 houses on a lot, which is in compliance with our regulations. The other part, you can't have more than 3 parcels? 3 parcels that take access off of a driveway. I didn't see anything where this is more than 3 parcels off of the driveway. But if it is, that's something that we'll deal with when it gets to him filing the minor plat. And we have people that do that. They'll come in, they'll put a minor plat in, or they'll put a plat in for us to record, and we'll say, hey, you can't do this without going before the Planning Commission to ask for a waiver of that rule. So those are all things at staff level that we're going to catch, that's all included in those conditions of approval for things that are going to be required prior to a short-term rental permit ever being issued to this applicant if you all choose to pass this today. So I think that may clear up those 2 things.
Okay. Thank you, Ryan. Okay, final statements by opposition? Final statements by applicant?
Mr. Chairman, members of the board, again, appreciate your time, appreciate, we've now been here twice on this, and again, we got the last situation done. I just want to put the summary back on again. We appreciate all the discussion, all of the questions, the concerns, being able to address those as we move along here. Again, it continues to be Mr. Bowman's goal to work with his neighbors on rectifying whatever issues might be out there to essentially address any concerns. But for purposes of today, again, we would ask the approval of a conditional use permit so that they can use the residence for short-term rental purposes. It does qualify because it is an owner-occupied host property. It qualifies because it's essential and desirable to the applicant, his family, and the community at large, as we've already talked about and has been in the record. And it also qualifies because it comports with those objectives of the Oldham County Comprehensive Plan that I talked about before, because as a practical matter, it offers some synergy between that property and other businesses in the county. So again, it meets all the criteria for a short-term rental conditional use permit, and I would respectfully ask, again, that you all consider that and hopefully approve that. Thank you, Mr. Chairman.
Okay, thank you. Okay, we're closing the floor for presentations and have discussion among the board. Nothing?
I'll just start. I'm in favor of approving this, and
Okay.
I think it's, yeah, it is. I'm just quiet.
We ready for a vote?
Somebody's going to make a motion.
Yeah.
Yep. Need somebody to make a motion.
I'll make the motion. Move to approve OC 25-049, the conditional use permit, because the proposed use is desirable to the community and not in conflict with the elements, objectives, and policies of the comprehensive plan based on one or more of the following factors. First, the community does have a need for the proposed use, and there are potential benefits to the community and neighborhood. The proposed use will not impair the integrity and character of the zone, with restrictions in place for like the number of people, et cetera. There are adequate public facilities available, such as transportation, sanitation, water, sewage, drainage, emergency services, and recreation. This is all based on evidence and testimony provided and introduced in the November 20th, 2025 hearing and the December 18th, 2025 hearing. There are potential conditions of this approval. It shall only apply to this application considered during the December 18th, 2025 Oldham County Board of Adjustments public hearing. The applicant shall comply with all regulations concerning short-term rental properties as outlined in Oldham County Zoning Regulations, section 250-050. The conditional use permit will automatically be revoked upon transfer or sale of the property. The applicant shall apply for and be issued a short-term rental property permit before renting the property. And the owner shall submit a minor plat application separating the second structure to an independent parcel prior to the issuance of a short-term rental property permit.
Is there a second?
I'll second.
Mr. Chairman, one clarification.
Yes?
You said the potential conditions of approval.
Oh,
That's
they
new
are the-
striking
sorry.
Potential, correct?
Yes.
So they are the conditions of approval.
And I might also add, you got the rental property permit and license before.
Oh, and license,
Okay.
yeah.
Yes, okay. Okay, we have a second.
Yeah, I'll second.
All in favor?
Aye.
Aye.
Opposed?
Aye.
One opposed? Abstain? Okay, motion passes. It's approved, 3-1. Thank you. Okay, next we have OC 25-050 for our rear yard setback variance. Madam Secretary?
Okay, 0C-25-050, an application has been filed requesting a rear yard setback variance for property located at 3604 and 3608 West Highway 146 in LaGrange.
Thank you.
Anna Bard, Senior Planner. This case today is at 3604 and 3608 West Highway 146 in LaGrange. The reason it's two addresses is because it's two lots right now, and they're going to consolidate the lots into one. So they're requesting a rear yard setback variance. And this is the proposal Ms. Tapp just read. So on one of the lots, the zoning is R2 residential, and on the other lot, it's C1 commercial, and you'll see that in the map in a minute. The land use is undeveloped, and it is 0.36 acres. So this summer, in May and June, they filed demolition permits for each lot, and the buildings on both properties have been demolished, which is why we're saying the property is undeveloped, because there's currently nothing on there. And then on December 9th, 2025, the Planning Commission recommended approval of a zoning map amendment from R2 Residential District and C1 Local Business District to R4 Residential District. Additionally, the Planning Commission approved the development plan for a 5-unit apartment complex. So if this is approved today, the next step would be for them to go to the legislative body, which is fiscal court. So the agenda for this case was posted to the website on November 25th. Adjoining property owner notices were mailed on December 1st, and public notice appeared in the Oldham Era on December 11th. And like I said, that Planning Commission action happened last week on the 9th. So this map is facing north. So there's the existing apartments to the north, and then the jail is down here closer to us on 146, and 393 is this direction towards the west. And if you keep going south far enough, you'll hit Commerce Parkway and the Buckner Kroger. So here's that zoning map. As you can see, one of the lots is zoned C1 commercial and one is R2 residential. We have R4 to the north with the existing apartment complex, and then we have some commercial and residential zoning around, along with this industrial zoning to the east, and the PUD for the Buckner crossings. It's the Buckner Kroger is part of that PUD to the south, and the railroad in between that. So the applicant is requesting a rear yard setback variance for a 0.36 acre tract to build a 5-unit apartment complex. The applicant is going through a rezoning process to rezone both the 3604 and 3608 to R4 residential district. The Planning Commission considered their zoning map amendment and development plan at their December 9th meeting, and they recommended, they have to recommend approval of zoning map amendments because it's the legislative body that approves those, and they did that, and then they approved that development plan. And then according to zoning ordinance 090-020, the rear yard setback requirement for R4 is 25 feet. The proposed rear yard setback ranges from 4 feet to 11 feet. The applicant is requesting a variance of 21 feet for the rear yard setback variance to allow for a rear yard setback of 4 feet. So I highlighted those areas here. As you can see, the lot angles down, And this is they faced their plan the opposite direction. So this is actually facing south with the apartment complex. This is 146 right here, and the apartment complex that exists is to the south of here. So this is their one building right here, and I highlighted this is 11 feet on this side and 4 feet on this side due to the property line angling down, and they have their parking over here. So this is where they're asking for the variance, and they're asking for the smaller of the two because that's just the simplest way to go about it.
And is that a railroad right-of-way all the way from the back of that to the railroad tracks?
Where their property ends, I believe, is where the right-of-way starts. So they're not going past their property. And the railroad company, I do have emails if you need to see them where they were okay with this project. They had zero problems with this project. And I did actually get answers from the railroad in a very quick time frame. So, yeah. It was fantastic. So here's the R4 zoning and the rear yard setback requirement of 25 feet. And then here is the picture of the site. So when I put the zoning signs out, I put one for each lot since they're being rezoned from two different things. And that's the railroad that you can see in the back. And this is just another view of the property. So in summary, their proposed rear yard setback variance case is the required rear yard setback for this lot is 25 feet. The requested rear yard setback at the shortest side is at 4 feet, and the variance requested is 21 feet. So for the potential conditions of approval is the variance shall only apply to the application considered at the December 18th, 2025 Oldham County Board of Adjustments meeting. Please note they can't move forward with the building process until they get the zoning map amendment approved. So they're kind of chugging along two things at once. So they won't be able to continue the process. If approved today, they won't be able to continue the process until they get that legislative body approval. So, thank you.
Okay. Thank you, Anna.
May I take a look at the email?
Yes.
Thank you.
Okay.
I'll put them on the overhead. Is that okay?
Yeah, that's perfect. I was forwarded through a lot of people to get to this point, but as you can see, they say as long as you remain off the CXX right-of-way, which they're doing, avoid any potential track fouling, which I believe they're doing, and they can speak to that, and ensure the drainage does not flow into the CXX ditch, which for the drainage part, they go through the county engineer's office. We do not anticipate any issues with the proposed development. We recommend installing a 6-foot-high construction fence along the right-of-way prior to construction to clearly delineate your work area from the CXX property. And with that measure in place, we should be in good shape to proceed. So that was the final of the emails. I think I have like several pages because I got forwarded through so many people before I got to the guy that actually makes the determination. So is that sufficient for you? Yeah, no, thank you.
Okay, awesome.
Okay, thanks, Anna. Okay, presentation by applicant.
Mr. Chairman, members of the board, again, good morning. Mike Swanser, 117 West Main Street here in LaGrange. I also have with me this morning Derek Triplett, who's the engineer on the project, and Billy Delker, who is the owner and developer of the project. And I assume if it's better and more efficient for all of us to just go ahead and stand up now, and for those who are eligible to be sworn in, and just in case they have any responses or testimony to give.
Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth? Thank you.
Okay, as Ms. Barge indicated, we were actually here last week in front of the Planning Commission on this case. So I've got a presentation that is actually slightly modified from the one that I gave to the Planning Commission last week, just for everyone's benefit to keep some consistency with it. But I do, this is going to be different than what the Planning Commission did see because you all are considering a different proposal than what the Planning Commission, or at least a different part of the process than what the Planning Commission did consider. So a lot of this is going to be repetitive, but I want to make sure, not just for your benefit, but for mine in terms of articulating it, because it's also helpful for me to verbalize it as well. But again, the request, as you've already heard, is that the applicant is seeking a variance of that rear yard setback for the standard for the property zoned R4 set forth in section 090-020 of the Oldham County Comprehensive Zoning Ordinance in furtherance of the proposal to develop those parcels located at 3604 and 3608 West Kentucky Highway 146 in LaGrange into, as Ms. Barge indicated, that new 5-unit apartment building across from the existing Oldham Point Apartments. So mine's a little different than what you saw earlier. And as we indicated, mine is essentially, the orientation of mine is such that it's facing north to south as if you're looking at it on a map. This is the rendition or the overhead of the particular property, as you can see here. And this is the development. So Kentucky 146 is right here. As we already talked about, the CSX railway runs through here. This is the property line. This brown square or rectangle is where we're talking about the development. I'll get more into this, but if you were going to get a visual of what that 25-foot rear yard setback looks like, this line, as it disappeared, this line right here is 25 feet. That's what we're talking about in terms of the setback. So let's get a little bit into it at the end. And again, 4 feet at this position here, 11 feet here. So guiding standards. So I always like to talk about what it is that you all need to consider in terms of the standard by which you all might consider a proposal like this. Section 350040 of the Oldham County Comprehensive Zoning Ordinance provides that this body may approve dimensional variances or spatial variances for property in Oldham County upon the finding of the following. There's 3 subconditions on that. 1, that the strict application of the zoning regulation would deprive the applicant of a reasonable use of the land in a manner equivalent to the use permitted other landowners in the same zone. So in other words, it was the strict application to this applicant would deprive the applicant of an ability to develop the land in a manner consistent with others who have property of the same zone classification. That's point 1. Point 2, that the unique conditions and circumstances are not the result of actions of the applicant taken subsequent to the adoption of the zoning regulations. So in other words, you can't create the situation whereby you're now asking for a variance of that situation. And then the third one is that the request will preserve and not harm the public safety and welfare and will not alter the essential character of the neighborhood. That's found in Oldham County Comprehensive Zoning Ordinance Section 350-020 sub 2 A through B. That is where the guiding standard for the Board of Adjustments is for a spatial variance request. Strict application of the standard. That's the first one we want to talk about, that substandard. So change in the zoning map. So we're talking about here a request to, and on December 8th, as we talked about, the Planning Commission considered this in the context of a zoning map amendment and overwhelmingly approved. I think it was 9-1, if I remember right, something to that effect. Someone correct me on it. It was something to 1, a lot to 1. Overwhelmingly approved the proposed amendment to the zoning map to change both the present zoning classification for the property at 3608 West Kentucky Highway 146 and the present zoning classification located at 3604 West Kentucky Highway 146 from R2, which is this area here, and C1 respectively, both to R4. So the Planning Commission made that recommendation, as already been discussed. That still has to be approved by the legislative body for finality. So there is still at least one more process to get that done. So we're actually doing this on a parallel track, if you will, to see if we can get them done at the same time. But as was already indicated, to the extent that if you all approve that, and then let's say, I think it's the city of LaGrange, right? Or is the fiscal court? Okay, I can't always tell where the city line is. But if the fiscal court denies our request for the zoning map amendment, then of course the project doesn't move forward, regardless of whether you all approve it, because it would not be zoned for the purpose of the construction that we're talking about. So again, there's still at least one more process that we would need to go through before this actually can start construction or start working with planning and zoning staff to do that. I want to talk about that standard a little, get into it a little bit, just in case you're not entirely familiar with how this works out, or if you haven't seen something like this before, I wanted to walk through it a little bit. So the rear yard setback standard for R4 zone property. So, and the comprehensive zoning ordinance breaks down property types by zone, right? So you've got C1, C2, C3, R1, R2, R3, R4, for example. You've got a whole bunch of other types of properties. R4 is the one that we're talking about here. That's the one that was approved by the Planning Commission. That is the one that would have to exist in order for this project to move forward. But what is the standard for an R4 residential district? Well, in addition to all the other things, as you might have already seen highlighted, the minimum rear yard setback for an R4 property is 25 feet. What does that mean? That means that if in a regular standard R4 property, the property owner cannot build a structure within 25 feet of the rear property line or the property line that's opposite the entrance of the property. So on this little diagram here, for example, the greenish area is your buildable area. This is where you can build. The rear yard setback is 25 feet from the property line. So you cannot build within 25 feet of that rear property line absent a variance approved by this particular body. So that is what we are seeking here today, just to kind of give a little more explanation as to what we're actually asking for in this context. If you haven't seen this before, if you have seen it before, I apologize for restating something or patronizing you. I don't mean to do that, but if you have not seen this before, this is what I'm talking about. A little bit more of a close-up here. So consistent with that R4 property designation, the one that was approved again last week, and the one that they're asking the fiscal court to approve, is that with a multi-unit apartment structure, so again, this rectangle here, located off of Kentucky Highway 146, which is up here. So to do that, again, under the current standard, they would be prohibited from constructing within this 25-foot area from the rear of the property. So again, the entranceway is here. This would be the rear of the property, so the rear yard setback is 25 feet here. This is where they would not be able to build absent a variance. So they could only start building at this line going here until they reached another setback. That would essentially be where they were limited to building. So we're asking for the approval of a variance, and this is where it gets confusing for me sometimes, so I want to make sure I explain it. What we're actually asking is a variance of 21 feet. So the standard is 25. We're asking a variance of 21 so that they can build within 4 feet of the rear property line. So again, the variance request is 21 feet, so that can be reduced to 4 feet where they may be able to build the structure. That is what we're asking for. And this is, and again, as Ms. Barge indicated, it's simpler to ask for it at its narrowest point rather than potentially out here. That's not going to work for the narrow point. So we just asked for the narrowest point because assuming it's granted for 4, then certainly it would be allowed within 11 as well. So that's why we're asking for the 21-foot variance as opposed to another variance, for example, like 14 feet. So comparison to neighboring properties, that's also a consideration that we need to talk about, right? To the extent that an application is denied, will it deprive the owner of the ability to use the property in a manner that is consistent with other property owners who have similar property zones? And the answer to that one is actually pretty easily identifiable simply because there's already a property literally across the street, Kentucky 146, that is zoned R4, where they have already been constructed multi-unit apartment complexes. That's the Oldham Point apartment complex. So again, the applicant in this case, if they are denied, would be deprived of the ability to develop this property in a manner that is permitted and has in fact been approved and already implemented or executed, if you will, across the street in this property, which is zoned R4 and has already been developed as a multi-unit apartment complex. So again, we would argue that it would deprive them of the ability to do the same thing that the owners across the street were able to do. And that's just for illustrative purposes. Changes to the surrounding community. So that's, again, this is the second factor that we want to talk about as part of your consideration. So I pulled this up. We showed this to the Planning Commission. I wanted to pull up again. This is what, for those of you who may remember, this is what this particular stretch of Kentucky 146 looked like back in 2018. There's trees there on the sign. These are single-family homes, for example, that are lined along this particular route. At this moment in 2018, this was the snapshot that Google took. So you can see what it looked like just 7 or 8 years ago. But since that time, there have been significant changes in the area that we believe support this particular project. One is the Oldham County Detention Center opened in 2018, and it's just 400 feet from the property line of this particular request. So again, that was something that did not exist until 2018. It opened in 2018. That fundamentally, in many ways, changed the area with the development of that particular property. Again, just 400 feet to the east of this particular property line. So you already started to see a little bit of a change in the dynamic of the neighborhood. However, there was also, just across the street, constructed the Oldham Point Apartments. So again, some of those single-family homes that had either been businesses, for example, had been vacant, had been run down, at least as after 2018, in many ways were torn down and replaced with multi-unit apartment complexes. And in a lot of this, and we talked about this at the Planning Commission, I don't want to get ahead of Mr. Delker if he wants to talk about this better than I can. But one of the things that came up at the Planning Commission, I just want to reiterate to the public and to this body, is that the demographic and economic makeup of this county has changed pretty significantly in the last few years. And it's not just Oldham County, quite frankly, it's actually nationwide. And a lot of this has to do with the post-COVID world we live in, where construction prices, for example, have skyrocketed, labor costs have skyrocketed, and that has led to a lack of building of single-family homes in many ways. So people who want to live in Oldham County, who want to avail themselves of the great school system we have here, who are going to pay taxes here, need a place to go, but they can't afford $500,000 or more homes on a single-family plot here in Oldham County. So they're looking for other means by which they can move into Oldham County without having to worry about breaking the bank. And one of those methods, or one of those opportunities for them, is multi-unit apartments or multi-unit condos, for example. That's not this project, but there are other projects where you talk about that are not going to be as expensive. You may not have the nice yard, you may not have the fences and all that good stuff, but you do have your ability to get the foot in the door here in Oldham County so that you can start that life here in Oldham County and hopefully eventually get yourself to a point where you are able to move into that dream home of yours. But you got to be able to start somewhere. And so we have to give people an opportunity to get their foot in the door. And we believe that a mechanism by which they can do that, again, is these multi-unit apartment complexes. Not everyone's crazy about that. I understand that. I respect that. But the reality, again, from an economic perspective and a demographic perspective, is that there just aren't as many places here in Oldham County for people to move to avail themselves of the opportunities and the benefits and resources we have in this county, and to make this county even better than it already is. So again, simply stated as the bottom, the unique economic and local conditions precipitating this development are not the result of any actions by the applicant. They didn't create this environment. They're a product of the environment in many ways, but it was done subsequent to the adoption of the zoning regulations. So again, the environment under which they're asking for this particular request, what they're trying to do with this project, was not a creature of their making, but it is something that they are trying to respond to and something that they are trying to work within. And this again, is another reason why we would argue that this project hopefully would be approved by you all and eventually approved, again, by fiscal court. Preserving safety and maintaining the character of the neighborhood. So again, remember, 2018, you got that photo, you got single-family homes, you got the trees along there. That was Kentucky 146 for forever, right? For the longest time, that was Kentucky 146. Obviously, with the construction of I-71, for example, you've got traffic now that's coming off of 146. It's no longer the main artery between Crestwood, Buckner, and LaGrange. I-71 is. So a lot of that traffic has now been transferred over there. You don't have the same traffic. You don't have the same environment that you might have had when 40, 50 years ago when those homes were actually built for the first time. Now you're talking about most of it's kind of a local access more than anything else. There are efforts, of course, to change a lot of this area. Kentucky Highway 393, of course, is being revised in many ways. That's a transportation cabinet issue. But there are some things that are happening here. But again, we're talking about maintaining the character of that neighborhood. The character of the neighborhood has actually changed in many ways from what it used to be, and it's not because the applicant changed it. It's because, again, the conditions that we talked about before changed before we got here today. So consistent with the requirements, the proposed development is not going to harm or reduce the public safety. That's one problem, one area, one concern. It's not going to do that. To the contrary, the proposal will still have to adhere to all those standards for a multi-unit residential development in Oldham County, for example, a waste disposal. And again, on this, you talk about where waste disposal has to be located, parking, there has to be minimum numbers of parking spots, for example, to make sure that not only that you've got enough for the residents, but you got it for safety purposes. That includes handicap parking. Stormwater runoff, that's going to be a condition for any development that you have in this county. And this particular applicant will have to follow all of those rules. That will also impact what CSX was concerned about in terms of going into the ditch, for example. They're going to have to work with the county prior to putting a shovel in the ground to make sure that all of those issues are addressed at that time. And they will absolutely go through all those processes just like any other construction project would have to. Landscaping, among others. So there are a host of other requirements that this applicant will still have to meet that we believe are going to, again, support the idea of health, safety, and welfare of this area and are going to, again, be consistent with that new character of the neighborhood. We're talking about multi-unit apartments in that stretch of Kentucky 146 now. Now we're talking about another opportunity for that in that area that's kind of becoming the character of that neighborhood itself. Just for your benefit, this is a rendition of what that apartment complex would look like if given the opportunity to build it. And it's not going to, again, alter the essential character of that neighborhood, particularly when you compare it to the existing Oldham Point complex across the street. This is going to be pretty consistent with that. But again, we're not talking about a rundown piece of property or construction here. We're talking about, again, a high-quality piece of property that is going to be well managed by the applicant for the foreseeable future to ensure that the individuals who are going to be living here, for example, are well vetted, that any issues or concerns for multi-unit apartments that might arise in some way with the residents are going to be addressed by them. This is not going to be an outsourcing to an out-of-state, property management group per se. They're going to continue to manage the property, again, for the foreseeable future. It's possible anyone sells it at some point, but for right now, that is the goal, is to build a high-quality structure for individuals to utilize and then to maintain that for as long as they control that opportunity. So this is what we're talking about. This is what it would look like if it was approved. So again, big picture, we're going to step out for a second and just kind of give you all an understanding of what this looks like and what it looks like here in the neighborhood. So again, we're talking about it reflects the needs of a growing diverse population base in Oldham County and provides a means of increasing not only residential options, but increased tax revenue as well. I do think that's also an important part of this. You're talking about more people living here who pay more taxes. We're going to help support that school system. We're going to help support the road systems without sacrificing quality in construction or property management. In the sense of the big picture, here's Kentucky 146. Here's the CSX track behind it. The Oldham County Detention Center is right here, as we talked about. You've got a couple of businesses that are right here. This is where the Oldham Point apartments were built, the photo I saw, and we're talking about this property right here just across the street. There was a question, I want to make sure we talk about something here. I didn't put it in my slides, but I do, health, safety, and welfare. There is not a synergy between these two, for example. They're not joined together, so there's not amenities or anything like that over here where you would have these people going across the street to a pool or to a clubhouse or something like that, which might cause a problem with pedestrian traffic on 146. They're not connected to each other in that sense. There are consistent owners, but they're not consistent developments whereby you would have some kind of shared benefit that might entice someone to want to walk across 146. This is going to be a standalone property that's technically owned by a different group and would be managed separately from the Oldham Point apartment complex. But it is going to have a similar feel, a similar look to that, just for consistency purposes. So in summary, again, respectfully request that the Board of Adjustments here grant the proposed development of a variance, again, of 21 feet of the rear yard setback for R4 zone properties because, one, the strict application of that 25-foot standard that we talked about would deprive the applicant of the reasonable use of the land enjoyed by other surrounding developments in the same zoning classification, including that property that's literally across the street from them that's zoned R4, that is also developed as multi-unit apartments. Two, the unique conditions, both economically and locally, of the area have changed within the last decade, including, for example, the demolition of those previous single-family homes, completion of the detention center, changing market forces like I talked about, and all of those are not the result of actions taken by this applicant. Again, the applicant didn't create the environment whereby it now finds itself and is seeking approval to build this particular structure. And then three, the granting of the variance will not, we believe, adversely impact the health, safety, and welfare of the citizens in that area and will comport with the new essential character of that area that has already been changed and is continuing to be developed. That is all that I have at this point, Mr. Chairman. I don't know if anyone else wants to speak. If not, then we'll be more than happy to answer any questions that you all might have. They're sitting there, so I will say that is it for me, and we'll be more than happy to yield back whatever time we have. Thank you very much.
Okay, thank you. And I might also commend you for your maps. I was sitting there on my phone trying to figure out exactly where is this, but so your maps were helpful in presenting this as well. And I encourage us to get a really good handle on where these applications are located. Anything else from the applicant? Okay. Testimony from anyone speaking in favor of the applicant? Testimony from anyone opposing the applicant? Okay, so there's no more rebuttals or anything like that. Any closing statements that you
Can
have?
I jump in with questions?
Pardon me?
May I jump in with
Sure,
questions?
yeah, absolutely.
Okay. When did Key Homes purchase both of these parcels?
Billy Delker, 4751 Fox Run Road, Buckner, Kentucky, 40010. I don't recall the exact dates, but earlier in 2025, we bought the 3604 property first and then bought the 3608 property.
All right, thank you. I have some questions for staff as well.
Go ahead.
Oh, I have one more question. So your counsel indicated that it is your intention to maintain ownership of this and manage it yourself. I just want to hear you say that that is accurate.
That's correct. And I'll give just another quick vision on why we're doing this. So the Oldham Point property across the street, which was 3601 West Highway 146, I had first bought that home 20 plus years ago and operated my building business out of there. And then I subsequently bought the two houses adjoining that for just investment properties. And so as the traffic count in corridor has changed along 146 with everything happening at 393, originally my thought was we were going to do something like commercial on that property where we ultimately built the Oldham Point apartments. But as everything has been redirected to commerce, the exit 18 interchange, it just didn't make sense. In fact, we had a letter of intent from a small box retail store that ultimately backed out when some of that underpass, kind of stuff came to fruition. So that's why we ultimately did the Oldham Point apartments. Then as we were completing that project, with a significant investment, the eyesore, I don't know if you remember what it looked like across the street, but one of those properties had been vacant for a long time and murder had been in one of the houses, and then the other property was in disrepair. So to protect the investment across the street, we started trying to figure out how we could acquire those properties to continue to not only protect our investment, but clean up that stretch of 146. And so, as Mike already indicated, Key Homes is my main building company, and Key Homes manages a lot of other LLCs that I operate out of my office. And so these properties I will be an owner of both, but they will be independently operated so that if we ever decide to sell, we could sell just this side or we could sell the other side. There is no connectivity for amenities, trash, anything like that. They will be completely self-serving rental units.
Actually, since you mentioned that the property across the street was also constructed by your company, was there a variance requested for that, or was there one needed as far as rear yard setback?
I don't remember. Derek, do you remember if we had? I don't recall.
Yeah. I have a question. What does the county consider Highway 146 in terms of type of road? I think the applicant mentioned it was a local access,
It's really a question for our county engineer. I think it's an arterial, but I can't remember. It's a state road.
Okay.
It's a state highway, and I think local access, it's going to be a local access road after the access under 393 under the railroad tracks loops around by the what's the name of I can't think of the name of the plant that's right.
Clayton and Lambert, yeah.
So this road will not be the primary road anymore to get around there. So
Okay.
Yeah, so 393, where it kind of crosses over the railroad tracks, they're going to realign that through the Clayton and Lambert property back, through where the recycling center is, down towards the John Black community center, that area. It's going to get realigned completely.
Okay.
But we don't know when that's actually going to happen.
Yeah.
It may be a little while. It's been on the table for 20 years, so.
Yeah. Another question. Do you know if we have existing variance requests like this in the county for building apartment buildings this close to railroad tracks or other structures?
Well, I don't think I've had any that are along the railroad tracks at all, properties along there. I don't know if anyone else has in the past year or so. And to answer the question about when they bought the property, so 3604 was in June of this year, and 3608 was in May. And if you look at my presentation on the site history, they went ahead and quickly got those demo permits so they could tear down what they call the eyesores. I don't see what they were, so I can't know if I agree with them or not. So,
Okay.
Anna?
yes.
There was the letter from the railroad that had some requirements that they would request. Would planning and development ensure that those things happen?
Is that our role to really ensure that they put up a 6-foot fence, or is that between them and the railroad?
Well, I think it'll be on the building plans, won't it? I mean,
Yeah, when they get to the construction phase.
yeah.
And so that would,
It's one of the conditions, that it'll be a condition of approval, and it'll be on the construction plans.
So
Yeah,
don't
we
need-
can add
So we don't
that.
need to make it a condition of approval today?
You can include it.
Okay.
I mean, it may be overkill, but it's okay if we do it that way.
Okay.
wouldn't hurt if you want to. Yes.
So I have a question for Anna. So the back corner of the parking lot looks like it's closer than 4 feet. So the building is 4 feet, so they need a 21-foot variance.
So
Do we need a variance for parking lots?
no,
too?
not in this zoning. So in residential zoning, we don't have setbacks for parking lots. You've seen that before with industrial zoning. They do have setbacks in some of the industrial zonings for the parking lots.
All right.
I think we saw one on 146 as well. So that's probably what you're thinking of. But yeah, they don't have to have a setback for parking lots.
Okay, good. All right.
Thank you.
Go ahead.
If I may, just to clarify, we're aware of what CSX requested, and we're willing to install the 6-foot. It's a temporary construction fence, just to be clear. They just wanted a barrier to keep, construction traffic from wandering up into their right-of-way and easement, that kind of thing. I guess, and while I'm up here too, how do we get back to where's the big picture slide? Yeah, where was that? Oh, it's on the other. I guess what I wanted to just take a minute and point out, if you look at that broad view of all the properties that are along the railroad track right there, there as far as all the way down on that where Ashland Community Church is, so you can see the proximity that a lot of the existing structures are in proximity to the railroad track. In fact, like the play area of the church actually goes all the way up to the right-of-way. So there's multiple structures along that stretch that are within what we're asking for. So.
Okay. Any other questions from the board? Anybody else that has anything to present? Okay. So I can close the floor for discussion, have discussion among the board. Oh, did you have any final statements?
Just reiteration, Mr. Chairman. Again, thank you all for your time. Appreciate the questions and the feedback on this one. And again, we incorporate, obviously, as part of the original testimony, the additional statements about the concerns with construction, and would certainly be working on that front as well. So I would add that as part of the testimony. But just to summarize, again, we're asking for a variance of 21 feet from the rear yard setback for R4 zone properties because, again, one, the strict application of that 25-foot standard would deprive the applicant of the reasonable use of the land enjoyed by surrounding developments. If the variance is not granted, they cannot build that structure because they just won't have the land for it. They won't be able to meet all the other regulations that they've got if they're not allowed to build within that 25 feet that we're talking about here, absent that 21-foot variance. So again, that's subsection 1. Sub 2, again, the unique conditions, as we talked about, economically and locally of the area have changed in the last decade. And again, Again, talk about the destruction or the single-family homes being gone along a lot of that stretch now, the completion of the detention center, changing market forces that we talked about, and none of these, again, are the result of the applicant. These are efforts that have gone underway for various other reasons in the last decade or so. And then the third one, again, is we believe, again, that this particular request will not adversely impact the health, safety, and welfare of the citizens of the area and will, in fact, comport with what we would say is the new essential or character of that area that has existed prior to this particular application. So, again, appreciate your time, Mr. Chairman. That is all we have to say, and yield back our time.
Okay. Discussion among the board?
I mean, the thing that I'm still kind of hung up on is this really a reasonable use for the property, given the size of it? And is this too big of a deviation from the standard setback that we have? I mean, it's substantial.
In my mind, the setback rules probably are for public health and safety. I mean, if you have a fire, you don't want to be right on top of another building where the two buildings can catch each other on fire and things like that. So, but this is fairly unique in that it's, it's railroad tracks right behind it. So you're not going to, if the whole thing catches on fire, there's no building behind it that's going to catch on fire. So from a health and safety perspective, and especially with a fence back there, so tenants or children can't go back into the railroad tracks, I think all of that is addressed. I mean, I try to think, okay, why are these regulations the way they are? Why is there normally a 25-foot setback? And it's probably for that. It's for health and safety and ambiance. Well, the ambiance of a railroad tracks, I don't think we need to worry about that. So, yeah, it's a significant deviation, but looking at it just in terms of the project itself, I think it improves the neighborhood. I commend the builder for making the neighborhood, making the community better with this type of project. So I think it's, I'm not concerned about it, put it that way.
I have no concerns about this.
You have none? Okay. Any other discussion? Okay, closing for discussion. Anna, did you have something to say?
Just remember, if you want to add that, if you decide to approve this, if you want to add that second condition of approval about, making sure they follow what CXX recommended, you can. You don't have to, but that's a condition of approval you can add if you want. And keep in mind, you're just approving the variance, they've already gotten the development plan and zoning map amendment approved. So you're looking just at the variance.
I would suggest that if we do put a fence in there, that it's at least 6 feet, but they may want to go higher. I mean, just, again, from an aesthetics perspective.
Well, and the fence that the CXX was talking about was a temporary construction fence.
Oh.
So I would have to look back at their plan if they have a permanent one or not. I can't remember off the top of my head.
Okay.
Sorry, one last thing. And we don't, permit fences, they can just put up the fences themselves, but no one has to get a building permit for fences themselves.
Got it. Okay, thank you. Okay, is there a motion?
Yeah, I'd move to approve the variance requesting a rear yard setback in OC-25-050 because it will not adversely affect the public health, safety, or welfare, will not alter the essential character of the general vicinity, will not cause hazard or nuisance to the public, and will not allow an unreasonable circumvention of the requirements of the zoning regulations because the request does not impede the public safety and welfare in this area, and it will maintain the residential character of the area. Conditions of approval are that the variance shall only apply to the application considered at the December 18th, 2025 Oldham County Board of Adjustments public hearing, and the applicant shall abide by the request made by CSX for construction to occur.
And just so the record is clear, Ms. Tapp, it's the 21 feet. So we're going from
Correct.
25 to 4, and that's part of your motion.
Yes.
Okay, thank you.
I'll second.
Thank you. All in,
The second condition? Yes. I mean, in terms of following the CSX recommendation for construction, yes, we're perfectly fine with that.
good, thank you. Okay, motion, we have a second, all in favor?
Aye.
Opposed? It's unanimous. Thank you. Yeah.
Good morning, Sandy Bergroden, Oldham County Planning.
Public hearing 0C-25-051. An application has been filed requesting a conditional use permit for an event venue for property located at 1222 Cliffwood Drive in Goshen.
And I want to say this, you heard this project earlier this year, and there's been a change, and that's why we're here, in case you're wondering if this is deja vu. The property is owned R-2 residential, and it's currently an abandoned swim club. It's 4.27 acres.
Can you remind us what we did last time? I don't remember what we did.
I'm going to get to it in a minute.
Okay, all right. Thank you.
So the site history, there are 4 nuisances cases were opened on this property. This is prior to the current owner in 2018, 2021, in 2022, and 2024. The main concerns were overgrown vegetation, unlocked gates, and standing water. On March 20th, 2025, a conditional use permit for a private recreational facility and swim club was approved by the Board of Adjustments. And on March 25th, 2025, a waiver of the vehicular use landscape buffer area and waiver of parking regulations were approved. The case history for the project that you're hearing right now, it was posted on the website on November 25th. Adjoining property owners were noticed on December 1st, and public notice appeared in the Oldham Era on December 11th. So here is the property. Here is the zoning of the property. It's R2 and surrounded by R2. Okay, so the property at 1222 Cliffwood Drive was formerly a private club that included pools, tennis courts, and other recreational opportunities. The property was vacant for about 8 to 10 years. The applicant's initial plan for the property was to restore the swim club and occasionally host private events. A conditional use permit for a private club and swimming pool was obtained March 20th, 2025. However, the cost of installing the pool is not feasible at this time. The plan is to eventually add the pool by revenue made from hosting private events. The plans and layout of the property have changed since the March 20th, 2025 Board of Adjustments approval. Therefore, the Board of Adjustments needs to hear the application and either approve or deny the current application. In R2 zoning, Oldham County Zoning Ordinance, Section 060-040, identifies private clubs, event venues, and swimming pools as conditional uses. In addition, Oldham County Zoning Ordinance Section 250-220 and Section 260-340 also identifies private club, event venues, and swimming pools as conditional uses. The applicant is requesting a conditional use permit to operate a private club and event venue, eventually adding the pool to the location. So here's looking straight ahead at the property. This is Google Earth. Here's what the property looked like prior to the current owner, and they've already started cleaning up the property. So this is the original plan that was approved in March. You see, this is where the pool was going to be, and then over here, these were going to be some sports courts. And this is the new plan. So this is going to be like an outdoor pavilion, and they've added additional parking here. Eventually, the pool will go in this area here.
So are they just going to fill in the old pool then?
I'm going to let the applicant
Okay.
talk to you about that. Here was the original business plan. Now here's the current one, more streamlined to cater specifically towards an event venue. Here is the zoning, where it shows that it's a conditional use permit, both of these. So in summary, an application has been filed requesting a conditional use permit for an event venue for property located at 1222 Cliffwood Drive in Goshen. A potential condition of approval is that the condition of approval shall only apply to the application considered at the December 18th, 2025 Oldham County Board of Adjustments public hearing. Questions?
Name and address, and you need to be sworn in.
My name is Beth McBride, and my address is 13615 Rutland Road in Goshen.
Raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Good morning. I appreciate you all doing what you do. I've been here a few times, not just for this project, but some others, and the right thing always happens. I'm not a public speaker, so if my face turns bright red and stuff, so sorry for that. But I'm here today because I have gone after this project for a few years. I got your all's approval a year ago to open up the swim club, have a great space for kids to come, the neighborhood to have a community gathering place. And that's what I've been working for. Unfortunately, due to the cost of the project, the bank does not want to lend that much on the property. So I had to go back to, okay, what is plan D at this point? Because we've gone through a few. And what I have come up with is, what can I do to still make the pool happen? That's my end goal at the end of the day is how can I do it and how can I do it fast? Unfortunately, nothing happens on my time frames, but I did come up with a plan that we can still have a private event venue that has community gatherings. We can have stuff like graduations, sports and activity, celebrations, neighborhood parties for stuff like, derby when people don't have big plans or kids that they can't drag along, weddings, and a whole list of things that I could use to make some revenue until we have enough to do the pool. Since I got the approval last year, the response from the neighborhood and the county has been really overwhelming. I mean, people have shown up, they've asked for, how they can help and what can I do? And it continues to this day. A lot of people, that happens the first couple of weeks after a project is new and exciting, but it continues to happen to this day. And the support of not just the county, but our small community of Goshen has been tremendous. In my eyes, this project has not changed a whole lot, except for I need the pool on a phase 2 and to move it to a different location. The current pool is an aluminum pool. Part of my business, I sell metal for a living, so I thought, easy, I can get rid of this. But unfortunately, the labor and what you need to do to get rid of that is more than what you would receive selling the aluminum or anything else. So that's why I called the county. I originally thought I was approved to do all these things in the original conditional use permit. I've had to call them a few times to ask some questions, making sure I'm doing the right thing, and they've been wonderful. But I thought I was already approved for this, and when I called and said, hey, is it a big deal, or do I need approval to say I'm going to move the pool to the side yard? Could I have this property in use for a couple years, or a few years before I add the pool? And that's when they said, hey, I think this is a different conditional use permit. So that's why I'm here today, is to put the pool on a phase 2, so to say. I still want the pool. If a private investor showed up today, I would drop this today and go right back to the pool. But at the end of the day, it's a piece of property. I need to generate some revenue, and I don't want to lose the idea of the pool and what this could provide for the neighborhood. So that's why I'm here asking for the conditional use permit to add the event venue.
So what's happening to the old pool then? What are you going to do with it?
Well, when I called, I was just going to fill it in. And I was going to build a new pool regardless, but I thought I was going to be able to use a portion of that pool, but it just ended up being too costly. And for a new pool, it'd be easier to just fill that in and build beside the clubhouse. There's plenty of room, actually more room on this side of the clubhouse than behind it.
Are there any environmental issues related to doing that type of thing? Just filling it in, or does it need to be removed?
We are not the agency that regulates that.
I see. Okay. Okay. Good enough. I don't think I have any other. You guys have any questions?
Oh.
Okay, thank you.
Do you live in that neighborhood that surrounds this property?
I live on the other side of 1793 on Rutland Road, so I just cut through the neighborhood. Yeah.
Okay.
Yeah.
Thank you.
Okay, testimony from anyone speaking in favor of the applicant?
Mr. Chairman, members of the body, my name is Mike Swansburg. Swansburg and Smith, 117 West Main Street here in LaGrange. And I had the honor, for those of you who were on the board last time we were here, I had the honor of representing Mrs. McBride before, and I'm more than happy to stand up here. She and I did not get a chance to talk before today, which is why she's doing the presentation. I'm not here, but I do want to speak in favor of this particular project. We want to talk about a little bit about, just for everyone's benefit, what it was at one point. And there were some discussions. The big issue one of the biggest issues I would argue that actually came about the last time we were here, in addition to obviously just renovating the area, what was it going to do, was the parking. And there was a lot of concern from the neighborhood about the parking at the end of the day and how many spots there were going to be and whether there would be people parking on the streets. And there was some concern, there's some discussion about the fact that, and the applicant at that time made the promise, you will, and I think it ended up, I can't remember if it was a conditional of approval or not, but ultimately discussed that parking would be addressed and would ensure that anyone who was parking on those roadways was essentially prohibited from coming in, was asked to go elsewhere. There was, again, the parking was part of the original plan, but there was a question about overflow. There was a waiver granted in terms of parking, but what I did not get to talk to Mrs. McBride before today, unfortunately, but what I did get to see as part of this new plan is what I believe at the end of the day, that biggest concern that I recall from that time, at least from my perspective, was that this plan actually addresses significantly that parking issue. In fact, it looks like it doubles the parking. I can't say that it's one-for-one doubling, but it looks like on the left-hand side of the property there, you've got additional parking lots rather than what at one point I think was a batting cage we were talking about over on the left-hand side. There's actually more parking on the spot. And then you've taken what were the pickleball courts that were supposed to be on the right-hand side there and actually made it more parking. So that, in my opinion, actually addresses pretty significantly one of the biggest concerns that was raised last time. I know that Mrs. McBride and her husband have made this a pretty significant labor of love for the last couple of years. They have been trying to figure out many different ways to make this project work. In fact, if I remember right, you actually grew up utilizing that property. Is that correct?
My daughter did.
Daughter did.
I grew up, I did swimming, but at that property.
Right. So there's a history to this property too for Mrs. McBride. It's not just find a piece of property, try to make some money off of it. It's essentially has been abandoned for the last number of years. And as you've seen, there were multiple, at least 4, if not more at this point, complaints that were filed for various violations. People breaking in, for example, breaking windows or damaging the area, for example. It's become basically an eyesore in the middle of this subdivision. And what Mrs. McBride is wanting to do is to transform it into something that becomes useful again and becomes a place in this subdivision where people can go and actually be used. And it's not for those neighbors that surround in particular, at least from my perspective. It's not somewhere where they walk out their door and see an overgrown, abandoned piece of property. It's now being utilized. So again, I don't have a whole lot more understanding other than what's been presented today, but I would argue, based upon my understanding of the property, in support of this, that in the context of seeking a conditional use permit, It is properly zoned, as we talked about. The character and objectives of the proposed use are appropriate given what it used to be and what ideally it will be if you all approve it. So we're not talking about a fundamental reform of anything. We're talking about essentially using the space that is there for a purpose that can be beneficial and actually, again, something that is not an eyesore and simply an abandoned piece of property. The character of the area isn't going to be fundamentally changed other than, again, additional parking. But right now we're talking about open space that's not being utilized and is overgrown. So we're talking about, again, it being utilized in a positive manner. I am aware, although there may be individuals who are not excited about this property, as there were back when we originally asked for this particular location. I do believe there were many individuals at that time, and in fact, we had letters of support that were included in the previous plan proposal from the neighbors that were all excited about the particular property. Again, there are people who were not. I don't want to take that away, but there was a pretty significant number of individuals in this neighborhood who were excited about this particular property. So there is, in fact, a desire, a need by members of the community for this particular project. It is compatible, again, with surrounding land use. It's already there. In many ways, we're just talking about being able to use it in a manner that allows it to move forward and it no longer is an eyesore or, again, an abandoned piece of property. And I don't believe it impairs the integrity and character of the zone in any way. There are adequate public facilities there. You're not talking about having to put in new electrical area, new sewer systems, new anything like that. It's all built within already. There's existing infrastructure. So, again, this is not a project where you're going to have to make significant revisions of a nice piece of farmland out somewhere or to develop or pave over a nice piece of farmland somewhere that the community might be concerned about. This is taking a piece of property, again, that is right now not being used for anything except criminal activity and making it productive and making it beneficial and in many ways trying to help those in that community by giving a centerpiece to a subdivision that needs, or in my opinion at least, could really use a nice piece of property that's being used by the public in a positive, beneficial manner. So I am much in favor of this, as we talked briefly about this, as I was when you all heard this project before, and be more than happy to answer any questions about that project to the extent I recall, but otherwise would ask you all to support this project.
Thank you.
So I'll jump in with some questions. How many more people will this revised plan allow on site?
I'm sorry?
How many more people will this revised plan allow on site?
I don't think it will change that number.
Even with all the parking spaces?
I don't know that I could answer that for you, but I don't see it changing the number. I was still going to do all those things when I thought they were already approved for that fit that same need. So I think it's maybe 17 more parking spaces or something like that, but I don't believe that allowed for more people because our original plan was there was going to be a lot of bike traffic and people walking. And that's why we asked for a variance of less parking places because I didn't think I needed them.
Okay.
So I don't think that changes it a whole lot.
And I seem to remember from the letters of support in the prior case that there was concern about like late night traffic. And these new hours do go much later into the evening. Have you talked to surrounding properties about?
The hours actually are shorter. In my last one, the conditional use permit, it allowed for the property to be open till 11:30. I have changed that to make sure there's any music or noises off by 10:30 and everybody leave the property by 11 except for maybe some staff. So that has actually been a shortened time frame, so it will close earlier.
Okay. And then was alcohol part of the previous application as well? Like serving alcohol in that application?
I had planned at a future date to look at that for a liquor license. I have no plans on that now after looking small into it and the liabilities and all that. If someone wants to rent somebody to come do that, they can.
And I think in the list of proposed uses, you mentioned after-school care and tutoring. I don't know for sure, but that might require, depending on the number of children, may require a different conditional use.
Okay, and that's fine. As I said before, every time something comes up or I have a question, I do call to make sure that I'm doing the right thing. Those are just all ideas that I came up with to generate some revenue.
Thank you.
Any other questions?
Actually, for staff, have we received any new letters for or against?
No.
Okay.
Okay. Thank you. All right. Testimony from anyone speaking in favor of the applicant? Testimony from anyone opposing the applicant?
Good morning.
Morning. Need your name and address and be sworn in.
My name is Glenn Gish, Gish. I live at 12008 Cloverdale Court, Goshen, Kentucky.
Raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth?
I sure do.
Thank you.
Yes. I've looked at this map. Excuse me. My property does not touch this, but I do. I'm on the left side of this property. There is a homeowner here that property butts up against that. This particular property has probably been abandoned for the minimum of 10 years. Has anybody on the board ever been there? Have they seen this property? No? Okay. I just want to confirm that. Please take a look at it. The property is extremely rundown. The cost of putting parking and renovating that particular property, I am not a contractor, but I'll promise you it will be tens of thousands of dollars if the owner wants to do what they're saying. This is Plan B. I suspect in another year or so, we'll be back up here to talk about Plan C. Because Plan B probably, and I don't know the answer to that, I'm not being negative towards the owner, but I don't think Plan B will suffice. The next situation that I think in the long term is filling that pool. If by chance that does happen, that restricts the property and possibly the ownership of that property the next time it comes before this board. That becomes an issue itself. You see the parking that has been displayed there. That is not there at this present time. That is actually an open field or grass. The circle is there roughly in a gravel type situation. The front of the building and other things are in very much disarray. I think that the owner has spent a good deal of money to try to bring this property back up. I know there's been some clearing involved and tree cutting and those type of situations. My major concerns are probably, I've got 9 of them, I'm sorry. Does this particular property, and I don't think it's on your all's jurisdiction, but does this particular property pass every fire code, exits, those kind of things? And I don't think that's going to be your situation. But if the owner is going to have events in this property, bachelor parties, bachelorette parties, we don't know what kind of events may or may not be there, and we don't know how many people may or may not come to those events, but they have to be secured. If this property hasn't been addressed, there's no way that that should be able to have anything in that parking. If the parking that is displayed there is put down even in an asphalt, that's got to be tens of thousands of dollars. Event timing, I've heard that it's moved back to 11 o'clock. Again, back to the size of the events, we don't know. At some point, if this is approved, would there be a band there that night? We don't know the answers to those things. The pool is still there, and if she's going to, if the owner is going to have events there, how are they going to prevent people from going around the back of the building or outside that building and possibly falling into this pool. It's very close. The pool and the building are not more than 20 feet from each other. And so that poses a problem. Liquor on the property, if you're going to have an event like that was mentioned, like any typical event, a derby party. I can't imagine that liquor won't be brought into a situation of that nature. That poses a real problem to this neighborhood. And again, I really hope that at some point, everybody needs to take a look at this and really see what we're looking at outside of what that picture is. There are homes that are directly across and also touching. The parking lot that's posed in this picture would actually oppose on the right-hand side would probably come up pretty close to some of the houses that are in that neighborhood. Security of the building. The building has become a real problem. I know that the police have actually been called over there numerous times, and that to me is another situation. To state that there has been an abundance of people that are for the first project, I can't address that, but again, I live on the cul-de-sac that's right next to it on the left, and I've never been approached by anything as far as what we should or shouldn't do with that particular property. And I still think that whatever is approved here, you'll be seeing Plan C soon, because Plan B, I don't believe in my heart will work. I'm sure that Mike will probably have a lot of rebuttal to this, and I think Mike's very good at what he does. I'm not, and I think he's fabulous. I think it's Mike. Anyway, his rebuttal will be a lot better than my discourse, and I do apologize.
Okay, testimony from anybody else opposing? No? Okay. Okay, let's see, where are we? Questions from the board?
Excuse me.
Sure.
There was two people that didn't stand up that was for the project before he came up.
Sorry, okay. Did you want to testify?
At 11804 Spring Meadow Lane, Goshen.
Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Everything that Glenn has said is true. The people in this area definitely want this pool. They definitely want her to succeed with this pool. It's been in this community for, 40 years. The kids all swam there, kids all played there. I think her intentions are great, and the community definitely does support it. Traffic is a problem, and I think that could probably be addressed if she had an event going on. Probably hire Oldham County Police to come over and patrol. But I agree with her. I agree with what Glenn is saying. Everything he's saying is absolutely true. And her intentions are definitely absolutely true. And I hope she succeeds.
Okay.
All right, thank you.
Thank you.
Anybody else in favor or opposing? Okay. Final statements from? Well, yeah, rebuttal. Is there any rebuttal or closing statements? Go ahead.
Am I good?
Yeah.
Okay. Just to go back on a few things that he mentioned about that is a that the parking lot up there is going to be new. It is not. I personally had big machinery in there. There is about 4 feet of gravel under the original approved, and there's about 10 or 12 inches of gravel where the new parking lot was approved this year. So there is there's already a foundation there. As far as a fence and bands and all that stuff, that could come with the pool, that could come with an event, that could come with anything that comes there. But that's why we would abide by any Oldham County rules, regulations, or ordinances to make sure that we are being good neighbors and don't want to offend anybody. And that's why we have an early cutoff time too. Security at the pool, it has been a problem for a long time. It has been less of a problem since I have owned the property for about a year. I do have cameras, and I call the cops every time someone shows up. I have a couple of neighbors, one with a new baby that's up all hours of the night and texts me at 1 a.m. if she needs to, if something's going on. But it has not been a big problem since I've owned the property. But that's one reason that I want to do something with the property, so it's not a problem anymore. And we have community, the neighbors in the community up there being able to enjoy the space. He talked about the fire department and all that stuff. That's out of my control. We'll have to do with building permits and all that good stuff. They will approve the right thing. But I do ask you to approve this project today. Without this, even with the original conditional use permit, which I already thought this was approved for, I do need this money to generate revenue to eventually get to the pool. Understand the concern that maybe filling that in, that the pool will not happen. I have that same fear. I really want the pool. That is my overall goal. That was my only intention in purchasing the property, was to get the kids out of the house, because these are the ones that are going to be taking care of me when I'm in a wheelchair, later on. So I think it's a great thing. It's a great project. The letters of support that I've received, I think last time it was 70 or 80 letters, and I had 3 days to get them. It was a great show of support from the community. But I would appreciate an approval for this so we can continue moving forward to get this pool done for the community.
Any rebuttal by the opposition? So I have a question for the opposition. What are you suggesting is the alternative?
Personally, I don't have an alternative, and I do apologize for that. I'm not against having something there. I really, really, in my heart of hearts, don't believe that there is a functional possibility of this happening. Now, God bless, I hope that changes, and I hope it does. To be very candid with you, I'm probably on the other side of that situation because I want to possibly move from that home. I've been in that home for 45 years and probably would like to. And I don't want that continuing to be an issue if I do try to sell the home. And I don't butt up to the home or to the property, but I'm fairly close, and I'm the cul-de-sac next door. If it ends up, and I'll go back to the original situation with the pool could be a great asset to some point. My grandson and granddaughter have swam for country clubs, and a lot of these clubs are in subdivisions, and this one would be prime of that. And again, we could be years away from a pool situation, but there is swim meets, and I'll guarantee you're parked all over the neighborhood. Now, she's not suggesting that we're going to have a swim meet there tomorrow, but if there's a derby party at this event and there's 50 people, something's going to happen. There's going to be other issues. And if a little community event is supposed to be for the families to get together or whatever, turns into something more than that, we don't know. We don't know the answer to that. Again, I'm not very well spoken in the situation, but I'm not sure that, honestly, you ought to take a look at it. And I know Goshen's in another world from LaGrange because 90% of those people don't even know where LaGrange is. I promise you. My wife's a terrified individual, or can testify to that for sure. Most of the people in Hillcrest don't even know that LaGrange exists. So anyway, I'm here to try to represent Goshen, and hopefully you guys will go over, take a look at what you got to look at. Thank you.
Thank you. Any closing statements, final statements? No? Okay. Okay, so we're closing the floor for discussion, and we have discussion among board.
Can I ask a
You have
question of
questions?
staff?
Sure, go ahead.
Okay. So I'm not completely sure what the conditional use permit request is. Is it a change to the site plan, or is it specifically that we previously approved a private club and swimming pool, but did not approve a private club and event venue?
The events were not the primary purpose of the facility. The primary purpose was the swim club, and the plan has changed.
Okay, because I remember us discussing events like swim meets, things like that. And I guess we did talk about the clubhouse, but I guess our prior conditional use permit was just for the private club and the swimming pool?
Correct.
Okay.
Well, they were there. That's where she was saying that she misunderstood. She thought that she was also having the events included in that conditional use permit, but now that's a primary use of this property until the pool goes in.
So now I have a question. So does that mean now we rescind the prior approval and she'll have to come back if she wants to put a pool there?
Well, that's why I've included it in the presentation, that it'll eventually be there.
Okay.
You know, if you look at on the first page of what the application has been filed requesting, that's all we're doing is approving that.
Okay. Got it. All right.
Thank you.
Good. Any other discussion or questions?
No, I mean, I commend the applicant for taking something that, according to those pictures, is such an eyesore and been such an issue for that community, and trying to turn it into something useful and might help beautify the neighborhood.
Yeah. Any other discussion? I agree. I mean I would be celebrating that someone's going to clean the place up if I was living in that neighborhood. So I think it's a plus for the neighborhood and for the community. So yeah, I have no concerns. Any other discussion? Is there a motion?
Sure. I move to approve the conditional use of the application that has been filed requesting a conditional use permit for an event venue for property located at 1222 Cliffwood Drive in Goshen, as proposed by OC-25-051, because the proposed use is desirable to the community and not in conflict with the elements, objectives, and policies of the comprehensive plan, based on the following factors: the character and objectives of the proposed use and potential impacts on the community and its surroundings are appropriate, and the community or neighborhood has a need for the proposed use, and that there are potential benefits to that neighborhood. Conditions of approval are that the permit shall only apply to this application considered at the December 18th, 2025 Oldham County Board of Adjustments public hearing.
Second.
Okay. All in favor?
Aye.
Aye. Opposed? It's unanimous. It's approved. Okay, we have the minutes from our last meeting. If I can find them.
Motion to approve minutes from last meeting.
Is there a second?
I'll second.
All in favor?
Aye.
Opposed? It's unanimous. Motion to close?
Motion to close.
Second.
All in favor?
Aye.
Aye.
Aye. Thank you. We are adjourned. Thank you.